Welcome everyone, I'm Russell Alexander. We often cover family law matters and related topics from one of our office locations, usually in the boardroom. However, in light of Ontario's state of emergency, I'm coming to you from my home office here in my living room. Our team continues to serve clients virtually to ensure the safety of staff, clients, and the public. Thank my daughter Sarah, who's helping us film today. During the lockdown, we encourage everyone to stay home and follow safety protocols. You can visit the COVID-19 Divorce Information Center at russellalexander.com to learn more. Without further ado, let's get into today's topic. Make sure that beneficiary designation in your insurance or life insurance is ironclad. When separated spouses are able to settle rather than litigate the support claims against each other, they will negotiate what is known as minutes of settlement, ideally with the help of the respective lawyers. This document solidifies and reduces to writing the specific terms of the agreement they have reached. In well-drafted minutes, it's not uncommon to see clauses that operate to secure or reinforce payment of spousal support from one spouse to the other. This clause will require the support-paying spouse to take out a certain amount of life insurance and designate the other spouse as beneficiary of the policy. That way, if the life-insured spouse passes away, the recipient spouse in the role of the named beneficiary is automatically entitled to the insurance proceeds, which are calculated to cover the amount of support that he or she would have received if the spouse were still living, and with the appropriate adjustments. The same approach can be taken to securing child support, with the children being designated as the policy beneficiaries. When negotiating minutes of settlement that include this type of clause, it is important to make sure that the language is clear. The clause should stipulate either that 1. The beneficiary is to be designated irrevocably under the policy, or 2. That the support payer insured cannot change the designated beneficiary without the spouse's or other beneficiaries' consent. It should also ideally stipulate exactly how the life insurance must be maintained by the insured spouse. If you're enjoying this video and find it helpful, you can give it a thumbs up or leave a comment below. As a really recent case illustrates what can go wrong when these steps are not followed. In a case called Kershaw, the separated husband and wife struck an agreement that child support owed by the husband would be secured by him. 1. By designating their 2 children as beneficiaries of his life insurance policy. And 2. Naming the wife as trustee of the insurance proceeds in the event he died before the kids reached the age of majority. This agreement, which importantly did not specify that the beneficiary designation was to be irrevocable, was duly incorporated into a court order. However, when the husband started a relationship with a new girlfriend, he secretly changed the beneficiary designation. He added her as 50% beneficiary and made her the new trustee of the remaining 50%. That the 2 children would now have to split. The wife and children found out only after the husband died in an accident, when the girlfriend received $189,000 in proceeds, plus $189,000 as trustee for the children, which she eventually did pay out to the children when they reached the age of majority. The girlfriend was sued for the other $189,000 she had received personally, arguing that the money should have been paid and used for support and maintenance of the children. They claimed that in law, she had been unjustly enriched at their expense and the original contract between the husband and wife should prevail instead. The court agreed. Although the case had some unique factual elements and some murky contractual wording, in the end the court concluded that the original agreement between the husband and the wife contractually required him to maintain the children as sole beneficiaries of the life insurance policy, which he had failed to do so. If only on the basis of public policy, it was important to uphold the now deceased husband's original bargain to use his life insurance proceeds to secure the child support he owed to the children. The court explained it this way. In addition to public policy dictates that the new girlfriend not be permitted to keep the funds. Spouses who enter into contractual arrangements to secure the payment of child support should be held to those bargains. It would be improper to allow the husband's designation of the new girlfriend as a 50% beneficiary to stand in the face of a previous agreement to the wife, naming her as trustee of those funds for the benefit of the children. The court acknowledged that from the new girlfriend's standpoint, she might have had a reasonable expectation of receiving part of the funds from the husband's life insurance policy. However, it could not take priority over the expectations in the wife and the children that the husband would comply with his contractual obligations and court-ordered obligations. Viewed another way, the girlfriend had been purportedly swapped in beneficiary only after the husband and the wife had already made their original agreement, stipulating something different, at a time when the husband was contractually not at liberty to make that change. The court ordered that the girlfriend must return the money with interest, and that it would be redistributed according to the husband's and wife's initial agreement. Please leave your thoughts and questions in the comment box below. If you liked this video and found it helpful, please give it a thumbs up to let us know. You can subscribe to this channel by hitting the bell icon and get notification every time we upload a new video. Thank you for watching.